If we can get started, because we're going to hit a time crunch where people will be denied lunch, and that's never a good thing. And there is a side event at 1:30 that people want to get to, so we've been asked to go until 1:15, but this is a defense panel, so we're going to ask equal time of the prosecution, of course. And, but we'll see what we can do to, as they say on an airplane, make up time in the air and see if we can move this along, because I'm sure there will be questions also out there at the end of this. So I just wanted, and I didn't get a chance to say, but good afternoon and dobar dan. I'm very honored to sit on any panel that's titled Defense and Fair Trial. I've had the opportunity to do that certain times, but not at something as significant as the ICTY legacy and discussing what it means in that context. I think it's quite an honor to be here in particular, and I'm already being told to slow down. This is what happens with the speed. It's an honor to be here because defense, as you will know, hasn't always been given a seat at the table automatically, and that's simply by virtue of the structure. Defense at the ICTY was never realized as an organ of the court, but that doesn't mean that there was great strides made and great progress, and I'm tremendously proud of where we've arrived as far as being invited to have a panel at this Legacy Dialogues to discuss the defense on equal footing with organs of the tribunal. So I do think that that is tremendously important. And like the OTP institutional development, we were talking about operational legacy. We're now going to talk about the operational legacy and development of the defense. And in particular, fair trial rights. And I'm afraid the words equality of arms are probably going to come up sometime during today and in the next hour or so. But fair trial rights are tremendously important. They're in the texts. We have Article 20, we have Article 21 that bestow those rights to an accused being tried. But you can have the words, but what do they actually mean? And that's where I think it's really important to look at what it has come to mean to all the parts of the courts, and what have the judges said about it as we've moved through the years. And we have, anyone would know in discussing fair trial rights about Judge Hunt's dissent, where the spreading stain, as it were. Basically that we won't be judged on the number of convictions or the speed of the trials, but how fair were these trials? And so we have an opportunity to discuss that now. And equally important, and to paraphrase Telford Taylor, if we're looking at Nuremberg, he said the trials there weren't just actually what happened, but what people believe happened at those trials. And he said the second is more important than the first. And I think it's a great opportunity now to look at that, and this leads me into the whiteboards there. What have we learned? What are the legacies? What are the conclusions and recommendations going forward? If you have thoughts out there in the audience that you don't get to share today, please write them on the boards out there, those whiteboards. Or if you don't feel comfortable doing that, there is an email, and you can send recommendations and conclusions so that we can further the progress in this respect. And just very quickly, because I don't want to take up too much time, but I do think the Association of Defense Counsel, then, obviously, I'm sitting here today because of the Association of Defense Counsel in many, many ways, has been tremendous in promoting that defense voice. It has developed in a way of organization for a variety of reasons at the very beginning that have been discussed and probably will be discussed. From our great panelists here, to moving into the building. I was actually head of office when they moved the office into the lobby. If anyone's been to the ICTY lobby, you know that's where the ADC office is and stands. In 2007, to actually now being recognized by both the ICTY and the MICT as the Association of Defense Counsel. And this is through even just a recent name change to reflect the fact that now, moving forward, this Association of Defense Counsel doesn't want to lose the institutional legacy, that institutional memory, and everything that the council and everyone who's contributed to the discussions have developed over the years. It's important to keep that and advance it into the legacy of the total body of the court. I'm not going to go into great depth because we don't have a lot of time about the biographies of the speakers, because that would take more than an hour and a half to discuss everyone's background here. They are in your booklets, and I'm sure they'd be free to discuss their past lives before. But we will go in the order that is actually iterated in the program, and we will one by one be introducing them as we go. And I just wanted to say that each of these people on the panel has influenced my own personal legacy as well, from being an intern with Ms. Vidovich on the very first case that I worked on at the ICTY, all the way to hearing about how OCO works and how it works as far as vis-a-vis where my position is today, and working with other people along the way and being influenced by decisions. It has been a tremendous honor to have a personal legacy that I think is important that we think about as well, not just the collective and what it is on paper, but what legacy has it meant to each of us, especially future generations of people coming forward. What have they had instilled in them by all of the legacy that's come before? And whether you're a victim, a defendant, or, as I said, just a humble, trying to be baby lawyer, it's something where you really have that personal legacy as well, and I know that everyone's thinking about it in these days here. So before I take up too much more time, I just want to start off with Honorable Judge Schoenberg. As you all know, Judge Schoenberg was a judge at the ICTY, both in trial and in appeals from 2001 to 2008, I believe, if I've gotten those years correct. But he has a background also as a participant in proceedings as a party, working as a prosecutor, and he's now doing defense work at an international level and has some experiences that he'd like to share with us as well there. In particular, he was going to be talking about the presence of defense counsel as a human right and theory and practice before the ICTY. And he has been given permission, it's specific permission to use the podium. He has been given such permission. And we'll take the floor. I just want to make one note about format. I'm not going to be that strict of a moderator because, like all good joint defense work, they've had a discussion about where they might be able to trade. Someone needs a little more time and someone needs a little less. So it's not going to be even Stevens across the board, but we will try to get this so that you can get to lunch. And thank you, Judge Schoenberg.
Thank you very much. Great to see that it functions. A very good morning to everybody, ladies and gentlemen. Thank you for having invited me to this great event. An accused party's access to fundamental fair trial rights is a key indicator of equitability in any system of criminal justice, as proceedings lose their credibility and integrity without the consistent application of due process standards. However, to rely on the notion of a fair trial without specifying exactly what the notion encompasses would leave us alone with the empty nut. It has to be filled with content. Today, it is to focus on the role of defense counsel as indispensable actors before international tribunals. It's for good reason to emphasize in the beginning that even though an international criminal tribunal like the ICTY is not party to either the ICCPR, here Article 14-15, or in particular for Europe, the ECHR, Article 5-6, it is bound by the human rights and fair trial guarantees enshrined therein. To hold otherwise would amount to a denial of justice. Before going into further theoretical details, allow me some observations going beyond the application of these human rights norms. ICTY, and not to be forgotten ICTR, had been born out of shame for the omissions by the international community not to have intervened in time in order to prevent the foreseeable atrocities. The two ad hoc tribunals have shown that the, at that time, unthinkable is possible. It is possible to bring, as far as possible for human beings, justice to an area dominated by rape, killings, deportation, war crimes. No perfect justice, but justice bringing and, to a certain extent, protecting peace by searching for the truth. also with an attempt to contribute to reconciliation. Lawfare, to a certain extent, has replaced warfare. Peace, fragile as it may be, achieved by permanently less weapons. The war was not able to silence truth normally dying first in armed conflicts. A dream became true that all the times had been promoted by the International Committee of the Red Cross since the first draft presented by Gustave Mounier. The broader message is, yes, war crime trials are possible if and in as far leading politicians of this globe so allow. Nearly all participants of this unique exercise of jurisdiction, guards, secretaries, legal officers, counsel, investigator, assistants for prosecution and defense in equality, members of the overarching registry, judges, and not to be forgotten, interpreters and translators, can be proud about their own individual contribution of this success story with all its flaws, its ups and downs. However, we are not here today to praise ourselves. Let me thank again all those having planned and made possible this unique event, taking place not far away from crime sites in a town tortured in a specifically outrageous way. This is an event to discuss the legacy of an UN tribunal open-mindedly and with a view to enhance the work of international criminal tribunals in the future. It must always be the question at the end of every story: what can be done to improve the work? What are the recommendations for tribunals in the future? How can justice in an even better way seem to be done? However, having framework now this context, I dare say that the fundamental question for me is and always was: why was it necessary to depart from a, in theory, functioning legal system in the former Yugoslavia, which was very close to the one to be found in other European countries? Isn't it true that criminal law and procedural law of a territory, this law reflects best the cultural, historical tradition people are positively acquainted with? To put it in legal terms of proportionality, yes, it was necessary and a great achievement that ICTY stepped in when there was factually no longer any functioning unbiased judiciary in place. Yes, no national jurisdiction could have brought so many alleged perpetrators to justice. It would never have been possible without the establishment of ICTY. And again, ICTR may also here in Sarajevo not be forgotten, to try former heads of states, of municipalities, high-ranking military personnel, representatives of politics and the media, responsible for the heinous crimes committed. Never in the history of mankind have so many war criminals been prosecuted. But coming back to proportionality test, was it also necessary to depart from the traditional European continental judge-led criminal procedure? Why was it necessary to impose a legal system people in the area of ICTY's responsibility are not acquainted with? Why is this question relevant for the legacy of ICTY and ICTR? The ICTY is based on the UN mandate to bring peace to this area. The fundamentum of our tribunal is, apart from the wonderful work done by Sheriff Bassiouni, the fundamentum of our tribunal is a statute based on Chapter 7 of the Charter of the United Nations, established as a measure to maintain and restore international peace and security. Believing consequently in the mantra that there is no peace without justice and no justice without truth, Why was it never possible for defense counsel to have unlimited access to all documents relevant for the case at hand? Even worse, the judges being the final arbiters of facts and law, how can they write a fair and complete judgment having no access to the entirety of available evidence? I'm not dreaming of an ideal world, but wasn't the legal system in place in former Yugoslavia far better equipped to achieve this goal by relying on one complete dossier, accessible for all participants in the courtroom in the same way? Only, that's this famous saying, only what is in the file or in the dossier is in the world, period. No need for defense counsel to search a needle in a haystack. No fishing expedition by judges striving for missing facts, having no own investigators. Further, the question before us is even more serious. It is about a clash of two never mergeable systems with two different philosophies. To win a case as a first goal for a party in common law, or to come as close as possible to the truth, which is indeed the mandate of ICTY. It is about the denial of full information about all available facts relevant for the case the court is seized of. This denial is not only infringement of the Roman principle dami hi factum dabitubius, give me all the facts and I will tell you what the law says about these facts. At that time, it amounts to denial of full transparency, not only for independent judges, but even worse, denial of transparency for the people on the territory of former Yugoslavia, our customers, I dare say, customers which should benefit as far as possible from the delicious fruits of justice seen to be done. Why this time-consuming procedure of presenting and accepting evidence piece by piece, followed at least on appeal in nearly each case by the protest about non-full disclosure? Based on my own experience in a similar legal system, it is far easier, less time-consuming, and far cheaper for the international taxpayer to reject some out-single pieces of evidence from the full dossier, if so justified and necessary, instead of admitting into evidence piece by piece. My personal conclusion on this general question of the applicable legal regime change is it was not necessary at all, thus not proportional, to also depart from the principles of a procedural system in place in former Yugoslavia. Statute and RP rules and procedure of evidence was part of a necessary invasive measure in the territory of former Yugoslavia. However, in particular, not the rules of procedure and evidence observed the principle of proportionality, dictating that always the lesser intrusive measure has to be used. Having opted for proceedings tailor-made to common law proceedings was a political decision that, seen in a broader context, does not and did not come with surprise. It was practice since the days immediately in the aftermath of the fall of the wall and the Iron Curtain in all countries of the former Soviet Union. Attempt was made by the US government or its agent like American Bar Association, CELI, now USAID, to convince the fresh established governments to adopt at any cost the Anglo-American legal system also, and this is difficult to digest, at least for me, also in criminal matters. Each system, no doubt, works in an established context. However, it was not necessary to impose a foreign system into an existing and well-working customary law of a region. Coming back now to the role of defense counsel before ICTR. The first pragmatic question is, was it necessary to deprive an accused from counsel of his/her own choosing, guaranteed in Article 14.3b of the ICCPR? This seems to be an overly harsh assessment, but isn't it true, in particular in the beginning of ICTY, that no counsel from former Yugoslavia could ever defend alone without assistance of counsel acquainted with the difficult to understand, digest, and practice Anglo-American system? Further, Article 14.3d of the ICTPR reads, "Everyone shall be entitled to defend himself in person or through legal assistance." The right to be assisted by counsel is paramount to the concept of due process, since it's a guarantee for protection from being arbitrarily arrested, charged, or prosecuted, to quote again Sheriff Bassioni. The ICTY's conception of the right to self-representation has undergone several shifts from absolute right facilitated by amicus curiae, and I don't want to walk through all this. I'll come back to this in a minute. Before taking a look at the history of self-representation with the UN ad hoc tribunals, it is necessary to understand what motivates an accused to defend himself, given the conventional wisdom that a lawyer who represents himself has a fool as a client. Unlike in civil law systems, where the accused is entitled to intervene in the trial proceedings whenever he deems it necessary, in common law systems, in principle, the accused does not enjoy this right. Instead, he becomes a mere object of his own proceedings as soon as he decides to be represented by counsel. His only opportunity to address the court directly is to give testimony in his own case. Given that the proceedings at the ICTY are driven by an adversarial model rather than an inquisitorial model, parties have to make decisions to either play an active part in the proceedings or not. However, again, Sheriff Bassioni rightly observes, representation of counsel is not only a matter of interest to the accused, but it is also paramount to due process of the law and the integrity of the judicial process." End of quote. Consequently, it's critical for the court to ensure the adequacy and effectiveness of legal representation. Whenever the court deems it to be in the interest of justice and in the interest of providing for effective representation of the accused, it must assign counsel to him of his own choosing, if possible. The disjunction of self-presentation or counsel, as it reads in Article 14.3d, was never meant to be understood as a dichotomy. Instead, the right to defense ensures the accused has an active role in the proceedings, the role of a subject rather than an object. Again, a quote from Sheriff Bassioni. Based on a sound interpretation, the word "or" in Article 14.3d of the ICCPR has to be properly interpreted by the word "and", thus reflecting the proper approach to a holistic understanding of defense, forming part of fair trial guarantee. Ladies and gentlemen, let me pause here for a minute for a pragmatic question. Isn't it true that there is a substantial likelihood that the majority of self-defenders, like, for example, Mr. Milosevic, before ICTY had opted otherwise had they known that, how it was common in the home country, counsel on their side would not automatically mean to lose their own standing in the procedure as active participant? In my humble opinion, It would have been less time and money consuming, even more fair. One of the fundamentally overly academic questions would have been rendered moot. Sorry that I mentioned in this context experienced and qualified. There is no doubt that ICTY had high-profile defense counsel from the very beginning. Judicial experience over several years being a prerequisite to act as counsel before ICTY. But what about judicial experience of self-defenders? And speaking now as a judge, not to speak about the absence of some qualification or experience for judges. I think it's a lot of lessons to be learned for the future. To briefly come back to the history of self-representation before ICTY. All the way back in 2001, the trial chamber in Milosevic stated that it would be wrong for the chamber to impose counsel on the accused because that would be in breach of the position under customary international law. Why this reference to customary international law when it was in practice in stark contrast to that what we had in Europe? Upon examination, this assertion does not prove entirely true. For instance, in Croissant versus Germany, a German regional court designated an additional defense counsel even when the defendant was already represented by two lawyers of his own choice. The court in Strasbourg confirmed this position when it, I quote, affirmed the right of states to assign defense counsel against the will of the accused in the administration of justice. The European Court of Human Rights emphasized that the right to self-representation is indeed subject to limitations and that, I quote, it is for the courts to decide whether the interests of justice require that the accused be defended by counsel. When appointing defense counsel, the national courts must certainly have regard to the defendant's wishes. End of this quote. ICTY, based on the Anglo-American system as it was, considered the right to self-representation to be an indispensable cornerstone of justice, as it was said by the appeals chamber. Hence, the appeals chamber allowed Milosevic to represent himself as long he was, I quote, physically capable of doing so, end of quote. The trial chamber had ordered the assignment of amici curiae to assist the court in the proper determination of the case. But the appeal chamber altered the role from friends of the court to friends of a party to the proceedings. What about conflict of interest when you work as friend of court and at the same time as friend of the party in the same proceedings? In a separate opinion, Judge Bedin stressed that the appeal chamber had illegitimately modified the role of an amicus curiae and that under the system of the tribunal, he is not legally competent to act as counsel for the accused, and he certainly is not an intervener. In sum, the misuse of amicus curiae as kind of mediator between the bench and the accused has proven also to be a fundamental mistake. In contrast to Milosevic, another trial chamber in Seychelles adopted a different approach when dealing with disruptive defendants exercising their right to self-representation. In response to a request by the prosecution to assign defense counsel to Seychelles due to the complexity of the case and the risk that Seychelles might harm the international tribunal by using the trial as a platform for political interest, among other factors, the trial chamber appointed a so-called standby counsel. Additionally, The court distanced itself from the trial chamber in Milosevic by declaring again that it would be a misunderstanding of the word "or" in the phrase "to defend himself or through legal assistance of his own choosing," to conclude that self-representation excludes the appointment of counsel to assist accused or vice versa. Finally, in November 2006, the trial chamber once again assigned counsel to Seychelles, who had been on a hunger strike. The appeals chamber was in the delicate position of reacting to Seychelles' deteriorating health condition while trying to uphold the integrity of the tribunal. In December 2006, the appeals chamber not only reversed the assignment of counsel to Seychelles, but also ordered the trial chamber not to impose standby counsel unless Seychelles exhibits obstructionist behavior fully satisfying the trial chamber, that in order to ensure a fair and expeditious trial, Seychelles requires the assistance of counsel. Hence, the appeals chamber, under pressure, and this should never happen, under pressure restored the full right to self-representation. Scholars and practitioners have criticized the appeals chamber decision as being of lamentable quality as it distorts the law in an effort to achieve the desired result. Some have suggested that the appeal chamber decision was a betrayal of the trial chamber's efforts to conduct the trial in an optimal manner, and Seychelles had finally succeeded in playing the appeals chamber against the trial chamber. In 2007, the question was whether a convicted person can represent himself on appeal. The appeal chamber ruled in the affirmative, stating that Article 21 4D of the rules of the statute draws no distinction between the trial stage and the appeal stage of a case. There is no obvious reason why self-representation at trial is so different in character from self-representation on appeal as to require an a priori distinction between the two. However, a dissenting opinion argued that the expeditiousness and fairness of the proceedings are intertwined. Therefore, when deciding whether the right to self-representation can be limited or qualified in appellate proceedings, it must be assessed whether such a step would benefit an appellant by ensuring his fundamental right to be the subject, not the object, of a fair and expeditious appeals process. An accused cannot waive his right to fair proceedings under whatever circumstances. To conclude, in my humble opinion, the overly doctrinal approach to permitting self-representation must yield to the fundamental right to a fair, public, and expeditious trial. Before international tribunals, assistance of highly qualified counsel is a must based on human rights. Nonetheless, the accused's right to participate actively in the proceedings, i.e. to defend himself or herself, must be protected. Joint efforts of accused and counsel are feasible and finally serve best the interest of justice and the accused, and far more importantly, serve best the addressees of any decision rendered by any international criminal court. The addressees, they are the citizens of the area of responsibility for the ICTY, former Yugoslavia. Concluding, I have to amend my personal, but it's not only my personal mantra, you find it in nearly all the religions of the world, that there is no peace without justice and no justice without truth. Let me conclude by amending that there is no justice without experienced defense counsel in the interest of justice. Thank you very much.
Thank you, Judge Schoenberg. For the next, we will have a PowerPoint, so whoever's responsible for popping that up, that would be fantastic. Well, we just heard about some legacy issues related to amicus curiae and the role that it plays, self-representation, in particular in cases of self-representation. And I think we have a conclusion recommendation right there in that we can't be over-doctrinal. I believe you said overly doctrinal, and it must yield to the overarching fair trial rights. I think there are some points that have come out there too related to disclosure practices, which is interesting. It sort of compels the thought that we created these systems from domestic systems to create an international system that now we're seeing being used back in domestic systems from what we developed in the international systems. And so almost a full cycle there, and learning where maybe certain things did work and certain things didn't work, and disclosure being a completely non-controversial, easy topic, that might be one where we can examine, and if you have any ideas on conclusions and recommendations, they can be made there, so that the fruits of justice are seen to be done, or as Judge Schoenberg just said, the delicious fruits of justice are seen to be done, which is a phrase I quite like. And now we are going to be hearing actually from Jasmina Pjanic, and thank you for that, Judge Schoenberg. She's going to be talking about the challenges of defending war crimes cases, how defense organizations operate in the region, and how they give assistance to defense counsel and their cooperation within the ICTY. And Ms. Pjanic is quite equipped to speak about this. She is the head of the criminal defense section at OCO. I'm just going to say OKO. Excuse me. And she actually was a part of the group that established the Criminal Support Defense Group. So she has a lot of experience in this and will be telling us, her thoughts on this today. Thank you.
Thank you for this nice introduction. Let me say it's going to be difficult. I'm not going to use a PowerPoint presentation because it's in Bosnian. I'm doing the lecture in English, and while the judge was talking, I was just crossing my thoughts, like saying, okay, I'm not going to say this, I'm not going to say this. So it's going to be quite short, I think, and I will just introduce you of my major experience and what I thought should be shared with you here. Basically, the right to an effective defense is a basic fair trial requirement. Furthermore, a judgment rendered in a case where the defendant was well represented will be more likely perceived as fair and just by public, and you would agree that is extremely important. Thankful to this principle, in 2005, 12 years ago actually, we established the criminal defense section known by its acronym OCO, in order to provide essential support to defense counsel representing defendants accused for war crimes, crimes against humanity, and genocide before Court of Bosnia and Herzegovina. And let me underline, that our jurisdiction is solely related to the Court of Bosnia and Herzegovina, and that is the first critic that I had to underline. It would be great if this kind of a support was given to all the levels through Bosnia and Herzegovina. The establishment of OCO is an important development in ensuring equality of arms. Actually, establishment of an office devoted exclusively to defense support in war crime cases at this early stage represents a step forward from the practice of the ICTY, where, for example, an arrangement to assist defense counsel previously did not exist. OCO was and still is a unique body in international crime scene. Please allow me to describe the facts we faced at our beginnings from 2002 to 2005. First fact, no bar association at the level of Bosnia and Herzegovina. Ergo, no official representation of defense interests before the state bodies of Bosnia and Herzegovina and international community. The vast majority of the international law sources and jurisprudence not available in local languages. Very little or no expertise in international humanitarian law among defense lawyers. No payment scheme for engagement in the most of the complex international criminal cases. New adversarial procedural legislation introduced without notice and training. No way to address the ICTY in order to access and obtain evidence. Finally, no clue how to deal with all that without money. So we took revolution path as follows. The criminal defense section and its relevant procedural rules were proposed by the registry of the Court of Bosnia and Herzegovina and adopted by the Court of Bosnia and Herzegovina in June 2005. The director of OCO was appointed by the registrar in consultation with the president of the court. The first two directors of OCO were internationals. Nowadays, OCO is composed only by national staff and headed by a national director. On the 1st of June 2009, OCO underwent a change of authority from the registry of the Court of Bosnia and Herzegovina to the Ministry of Justice of Bosnia and Herzegovina and became fully operational part of the BIH civil service. So let me transfer to what OCO does and how we support defense counsels. First and most important is legal advice. OCO's primary mandate is, in complex crime cases, to provide legal advice to defense counsel. This is one of the major tasks of OCO legal advisors, who are lawyers with previous experience in international humanitarian law. The OCO legal advisors are divided into several defense support teams. The current organization of OCO defense support teams is geographically oriented. This includes on-site and direct assistance at the main trial hearings, legal drafting and preparation of witnesses, preparation of BCS transcript summaries, reports on current legal discussions in forums such as law reviews and so on. Geographical division of the areas of the country allows the OCO lawyers to develop an expert knowledge of the factual issues related to a specific area, a detailed specialized knowledge of the evidence and even potential witnesses, an ability to advise defense counsel on the common issues related to that particular geographic area. Additionally, OCO provides assistance through quality research on international and neighboring national courts jurisprudence. It coordinates with national, regional, and international bodies, such as ICTY, in order to obtain and certify evidence. One more important aspect of defense office's assistance relates to the victim witness testimonies, namely, the transcripts of testimonies provided to ICTY can serve as potential evidence to be brought before the Court of Bosnia and Herzegovina. The OCO staff has access to the ICTY collection of documents through court archive and EDS. In assisting the Counsel, the OCO conducts research through all available databases, identifies relevant testimonies, applies for their certification, and submits the final product to a defense counsel-in-chief. Second part I just tackled, and it's access to evidence. Access to evidence to a single counsel requesting for information on his own can be a serious challenge, as you know. There is no state body behind defense counsel as a practitioner in this country. State-funded defense support institutions like OCO have a greater capacity to obtain access to evidence from state bodies. Namely, OCO is many times perceived as having more legitimacy than defense counsel himself, and that is unfortunate to reality. The disclosure of evidence has proven to be problematic for defense counsel within the entire region. In Bosnia and Herzegovina, based on the Freedom of Access to Information Act, the defense is authorized to file a request for access to information to the competent authority. However, in practice, the addressed authority responds with a delay or never. In cases of non-compliance, defense counsel may request the court to issue an order for access to archived materials. Third important point that we do is training for defense counsels. One of main functions is to provide courses for counsel that enables them to meet the criteria for admission to the list of advocates. I just had in my mind to mention that Bosnia and Herzegovina is probably one of the rare countries in the world which provides defendants the possibility to make their own choice of defense counsels, even in a case of ex officio defense, meaning budget finance defense. And we struggled about that a lot, trying to find, of course, it works well with the defense counsels, but we couldn't find later on the ground for that in the practice of the European Court of Human Rights, and it was really hard to argument, why would state pay for the ex officio defense of your own choice? But it still works and it functions well in Bosnia. Bosnia and Herzegovina is the only country in the region to prescribe rules regarding the training of defense counsel who appear in trials involving international crimes. Basically, when we started working with defense counsels, we realized, like, that they lack basic knowledge of international humanitarian law. You would probably remember from the earlier reviews, like that Bosnian law schools provide you just with a basic training. When you finish a law school, you're not expert in anything. And later on, our defense counsels would take different types of defenses. When the cases were transferred from ICTY, then we realized, like, that there is very few defense counsels who specialize in international humanitarian law. So our serious intention was, like, to provide the trainings. We organized two types of trainings. One was the basic training, which gave them, like, the basics of the Geneva Conventions, and just a couple of years after, like around 2010, we have seen a tremendous turn from basic requirements to specialist knowledge requests. So basically, we continued with continuous professional trainings with really specific topics. We would organize 1 or 2 days trainings, like, dealing simply and only with command responsibility, dealing just with the jurisprudence coming from ICTY. And then we realized, like, that we made a tremendous move from the basics from 2002, like, and we realized, like, that we have a really serious qualified corpus of defense counsels in front of ourselves. So we have learned that it is crucial to organize trainings on the ICTY case law, given the influence that ICTY jurisprudence is having on trials involving international crimes in the region of former Yugoslavia. This jurisprudence was new for most of the defense counsels. Therefore, is hardly any judgment of the Court of Bosnia and Herzegovina that does not make heavy use of ICTY jurisprudence. Other activities that OCO does. OCO conducts other activities in legal community with the region to ensure a widespread dissemination of information regarding international crimes, while providing support to others within the legal field. Because war crimes-related issues are still new to the regional's legal practitioners, one of the major barriers faced by counsels is the lack of literature on international criminal law in local languages. As you know, the most relevant jurisprudence and other materials are published in French and English. One solution that OCO has put forth is its publication and free dissemination of the magazine called OCO War Crimes Reporter. As I said, I crossed out most of the stuff that I wanted to say because I wanted to concentrate on just most important issues. And therefore, I'm going to underline that my personal opinion that most important lesson learned regarding the defense support organization, in our case, a criminal defense section, is independence. Independence is most important quality related to the establishment and functioning of any defense support organization. When providing legal advice to defense counsel, any such organization will undoubtedly be informed of the defense theory and strategy. In order to have access to all this information, there has to be a contract between the defense team and defense support organization, obliging staff of the latter to treat all the information as legally privileged. My conclusion, defense support institutions are a valuable investment towards the fairness and effectiveness of trials involving international crimes. Also, building national capacity is more important because more than 20 years after the establishment of the ICTY, we see the primacy of domestic jurisdictions enshrined in the ICC statute. States have the primary responsibility to prosecute before their national courts those who have perpetrated serious crimes of international concern. It is only where a state is unable or unwilling to prosecute that the ICC will take over. So we should bear that in mind. At the end, I will present you some recent statistics, and this is actually the point where we should probably need to get to the statistics. So, 12 years ago, we did not have a list of certified counsels who were qualified to defend before Court of Bosnia and Herzegovina. We published the criteria, opened the list. The list is still open, and we are proud to say, that on our list of Section 1, meaning defense counsel certified to defend war crimes before Court of Bosnia and Herzegovina, we have 164 defense lawyers. 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 164 defense It's probably less important for you to mention the Section 2, which deals with organized crime, economic crime, and corruption that we deal with too, so it's 106 defense counsels. Regarding our legal work, as you can see on this panel, in 2016, we did and we supported 280 requests for legal assistance before the Court of Bosnia-Herzegovina, meaning direct requests to support legal work of defense counsels on concrete cases of war crimes. 100 submissions, around 100 submissions to the ICTY, meaning submissions related to the request of the certification of the evidence from the ICTY electronic databases. And also we published one of our OCO report for war crimes. I don't need to read to you, 2015, 331 requests, and 2014, 330 before Court of Bosnia-Herzegovina. Finally, I will turn to the thank you note. At the end, let me conclude that the quality of defense counsels is strictly connected to the issue of compliance with the fair trial standards. I'm proud to say that Bosnia and Herzegovina has a large pool of defense counsels specialized in international humanitarian law, capable and willing to provide a highly professional defense. Finally, I will take this opportunity to thank to all my colleagues from national jurisdictions and international community, ICTY, OSCE, and EU delegation, for their historical contribution, and say that I'm personally and professionally proud and honored to be part of the joint endeavor we took in the last 2 decades. Thank you very much.
Thank you, Ms. Pjanic. It was great to have your firsthand view about how some of the initiatives taken and built into your office have developed systems, whether international or in domestic systems, to really make sure that they have training and capacity to meet those fair trial needs. And on your last point, that is, you did very strongly say that the training initiatives were what actually helped meet that fair trial standards, and your statistics are quite interesting, going from such a low number of people qualified to the numbers that you've put up there. I think that's really significant in looking forward at how other systems can build such capacity as well. So thank you for that, with highlighting the needs for the training, and specifically the specific topic of international criminal law, or criminal law itself, as well as domestic systems go, because I think a lot of times, since we are doing this every day, we forget we are in a specialty. It's the same as if we were in a tax law in a domestic system or anything else. You have a specialty. This is a specialty, and not everybody is trained in this specialty at a schooling level, and so the need continues to develop that. So thank you. We're going to continue on now then and get a little bit into some domestic work. Ms. Vasvija Vidovic, who has been a counsel ADC member and a counsel at the ICTY on several cases, including Orich and Delic, is going to be speaking to you now on the specific topic. I want to get the titles just right here. Of challenges of defending war crimes cases in domestic jurisdictions, including under the principle of universal jurisdiction. So this is where we're going back through the international and now taking it back into a domestic system a little bit. So Ms. Vidovic, thank you.
Hvala lijepa. Zaista mi je zadovoljstvo danas.
Thank you very much. It's really a pleasure to address this gathering because almost all my career has been devoted to work on this kind of cases. I have come here today to speak as an attorney, but when I saw Mr. Bob Reed's here, Mr. Tiger as well, I really felt the need to say a few words about the early period when the ICTY was established and started operating during the war in Bosnia and Herzegovina and the former Yugoslavia. I came to The Hague as a liaison officer when the only several persons from this country worked there. I was very concerned because the eyes of Sarajevo under siege were turned toward the tribunal. expecting the end and solution of the war in Bosnia and Herzegovina. So I was very concerned that there were only several people working there with the minimum financial support that was almost untenable. So I informed people about that wherever I can in Bosnia and Herzegovina and beyond, and we tried in different ways to make public the truth about the war in Bosnia and Herzegovina and the situation under the conditions under which the tribunal was working. No one believed that there would be any results by the tribunal, but today there's a theory that it has failed in achieving results when it comes to the completion of the war because the worst crime happened after it was established. But I'm a living witness that this happened because at the early stage there was little or no support from the international community in terms of capacity building. This took place before this terrible crime was committed. I heard what the member of the presidency of Bosnia and Herzegovina said yesterday, and it is true, because at the moment we all have our national perspective in observing the operation of the tribunal, but the tribunal has accomplished its mission, and the importance of its achievements will be something that future generations will be able to understand, because they will be liberated from the influence of daily politics. For me, as a former judge from the former Yugoslavia, it was a huge experience for me to see how cases were built in a completely different legal system, like the common law system, which is what the rules, procedures, and statute of the tribunal are mainly about. I also cooperated with the German federal prosecutor and German criminal police to identify evidence for an important case indicted for genocide under universal jurisdiction. This is a case that was effectively conducted in close cooperation between the ICTY, German prosecution, and the authorities of Bosnia and Herzegovina, and it's an example of how war crime cases can be effectively prosecuted before national courts using universal jurisdiction. As my colleague said, I worked on several cases, 3 cases to be more precise, as part of the defense before the ICTY, and I defended many, I was a defense counsel in many complex cases in Bosnia and Herzegovina in courts at different levels, in the Federation of Bosnia and Herzegovina and in Republika Srpska. In addition to the difficulties that all courts and law enforcement agencies are facing in countries in transition, it's quite obvious that the ICTY had an extremely positive influence on the case law of courts in Bosnia and Herzegovina, particularly in terms of imposing international standards in the prosecution of these kind of crimes and in other cases within the jurisdiction of these courts. It's a great achievement that the Supreme Court of the Federation of Bosnia and Herzegovina, as well as the Supreme Court of the RS, are correcting the case law of first instance courts in that regard. As Mrs. Tadic, acting chief prosecutor, said, this is very important because the entity courts will work more in the future to prosecute war crime cases than they have done so far. Others spoke about that, and let me go back to the experience that just few defense counsel have. I had an opportunity to represent the defense of a case conducted under universal jurisdiction in Norway. Courts in Norway, just like courts in other countries, have a very clear position when it comes to universal jurisdiction. When they took over from the ICTY to prosecute the commander of the military police of Croatian Defense Forces, the well-known Repa case, for crimes committed in the war in Bosnia and Herzegovina in period from 1992 to 1993. This was the first war crime case prosecuted in Norway after the World War II, and it was clear that courts in Norway had not had experience in prosecuting these crimes. However, the district prosecutor's office and especially district court in Oslo and the whole Norwegian public were extremely interested in this case and wanted to see its effective prosecution. From the perspective of the defense, the defendant had all and widest possible range of rights. The Kingdom of Norway, in addition to the fact that the defendant had an ex officio defense counsel from Norway, and because they didn't have defense counsel specialized in war crimes, the Kingdom of Norway realized that their defense counsel did not have specific experience in this kind of process, so they made it possible for the defendant to choose a defense counsel from the list of attorneys from the territory of the former Yugoslavia, for whom ICTY in The Hague established that they had the necessary experience in international humanitarian law. Something I will remember as a great experience is the fact how Norwegian judiciary brought the principle of the equality of arms to almost perfection, as well as the right of the defense. The defendant had time and resources to prepare for the defense, both in the investigation stage and during trial. The investigation lasted for a long time. However, the first and second instance proceedings were conducted efficiently. Main trials were conducted 4 days a week, and the prosecution was extremely professional and cooperative. They helped us, the defense, to locate witnesses and enable their access to court. The testimonies and contacts via video link were ensured. During the proceedings, we could see very close cooperation between Norwegian authorities and the State Prosecutor's Office of Bosnia and Herzegovina, and especially ICTY. They both submitted very quickly the material necessary for the proceedings to the prosecution and the defense. As I said, the prosecution helped the defense in terms of obtaining evidence. They were very professional and impartial. From the perspective of the defense, it was very important that the Norwegian prosecutor's office fully met its obligation of disclosure of evidence, which I consider the most important right for the defense. Because if that right is not met, then there is no effective defense. So we had all information that they obtained during the investigation, including audio recordings and of discussions with witnesses from the first contact they had, and this significantly contributed to effective defense of the defendant. If I were to compare this situation with the state of affairs at the Court and Prosecutor's Office of Bosnia and Herzegovina, regardless of the fact that their considerable progress has been achieved from the time when the court was established, and there's a huge contribution by OCO, they have limited capacity, and unfortunately, instead of being strengthened, they are being reduced, and this is not a good thing. So unlike this practice in Norway as well as in Germany, where the disclosure was done as described by Judge Schoenberg. And I saw that assisting in Jorgic case to locate some evidence, I observed that this did not work. Very often, prosecutors think that they fulfill the obligation of disclosure of evidence by submitting the material along with the indictment and making it possible for prosecutors to see evidence. But the events from the case were distributed to a great number of cases intentionally. For example, an event that lasted for only 2 hours was distributed to 7 different cases, and there were 7 different prosecutors filing indictments in their cases. This is how the defense is prevented from disclosure evidence about the same event which the acting prosecutor does not possess. It is rather his colleagues that have that. The fact that the prosecution is a single body is being disregarded, as well as the obligation of disclosure. I believe that the State Court of Bosnia and Herzegovina, since we appealed against this, will understand and recognize this as a serious problem. The disclosure to the defense is not done after the filing of the indictment, and the Joanna Corner reacted to that in cooperation with the OSCE, that provides huge contribution to the rule of law in this country, in cooperation with Mr. Bramertz, his staff, who have supported it, and I believe that this problem will be resolved. And I believe that the High Judicial and Prosecutorial Council ordered that the recommendations of Judge Corner should be followed. So the attorneys from Bosnia and Herzegovina are very thankful of Prosecutor Bramertz, the OSCE, and ICTY as a whole for improving the process of justice by taking this problem seriously. I believe that the AJPC will be consistent in making the Prosecutor's Office of Bosnia and Herzegovina and the Court of Bosnia and Herzegovina to accept and implement the recommendations of Judge Corner. So a lot has been done here, a lot has been achieved, but still there's a lot of room for improvement to endorse the principle of equality of arms and the importance of right to a fair trial. In my opinion, there's still a huge task for the Office of the Prosecutor of the ICTY and the Tribunal in general to help by way of trainings, as described by Mr. Bramertz. Because the current way the prosecutors act may lead to a lot of damage in the future. As regards the case in Norway, I think it's an interesting experience. What I was very much surprised with when I came there was that in Norway it is a jury that hears this kind of cases. These were some complex legal issues with elements of command, of responsibility of defendants. However, the way how the prosecutor represented this case, how he used experts who explained the background of the case to the jury, and help by way of expertise to clarify questions asked by the defense. This case was completed in a similar fashion as it is done at the ICTY. Something that was interesting for us who were part of the defense at the tribunal at first and then in Norway, the most difficult for the defense counsel was to present rules and regulations covering military service, civil service, command activity, prosecutions in line with the rules applicable in the respective state. There's a negative aspect of this trial in Norway. The only one for me was the fact that the trial court retrospectively applied Norwegian legislation on this case because the national jurisdiction of Norway, just like many other national jurisdictions, did not have this crime criminalized in their legislation. However, the Supreme Court of Norway corrected this mistake and finally convicted the defendant. So the judicial procedure in Norway enabled effective defense, efficient and fair trial, and that is why I believe that this practice is very important and may help in dealing with many cases, both in the former Yugoslavia. There'll probably be a tribunal established for Syria so that crimes are prosecuted under universal jurisdiction, because I have a very positive experience in that regard. Thank you.
Thank you, Ms. Vidovic. I think we've had further support. You sort of dovetail off the issues that were raised by Ms. Pjanic about the support and the training that's necessary from OCO. And in particular, in applying it to domestic cases, both for universal jurisdiction and helping countries to prosecute cases that they find important to them. I think it's interesting, the RAPAC case being interesting to the state of Norway. It was necessary then for them to find specialized knowledge from an international community to then support that in the best manner possible to achieve justice. And it's also important in all of the discussions of positive complementarity and things that we're trying to do to allow domestic jurisdictions to also take on some of the roles, so it's not just in the international courts, because there's too much to process there. Thank you for that. Again, we'll now move to our final speaker. This is Mr. Tomislav Snitch, who's also an ADC member and practicing counsel for the ICTY on several cases, Oidnich, Krstić, and many others. I'm not going to list them all now. Who will be speaking to the topic of challenges of defending war crimes cases and building a defense case, how the ICTY jurisprudence and practice has influenced defending cases in the region, and the adoption of the adversarial system. So we're kind of coming full circle back to some of the discussion of disclosure practices. Thank you.
Dobar dan svima I hvala na ovom uvodu.
Good afternoon, everyone. Thank you for this introduction. I will try to touch upon what my predecessors said and share with you some of my insights. I understand Judge Schoenberg when he compared the relationship between two systems, i.e. models of prosecutorial proceedings. In most countries of the former Yugoslavia, a new model was introduced. Some would say because there was a need to try war crimes, others would say through international pressure to try war crimes before national courts. However, the application of this model of the accusatory system and its influence on the system which had functioned through decades from the position of defense made things very difficult. those problems were particularly pronounced when it comes to the principle of a fair trial and the position of defense during the proceedings. I had the opportunity to work before the ICTY, starting with 1998. And from my point of view, the rules on disclosure and the role of defense both institutes were only put in place after 2003 or 2004, when the Institute of Pretrial Judge was set up, and the need to disclose before the trial itself, and when the Rule 68 was introduced, or pointed out. Mutual disclosure was thus abolished. So the Hague Tribunal introduced a number of changes in its own rules, started with 1995 onwards. There were umpteenth times the rules were amended. In any case, as of 2002 or 2003, those amendments became more frequent. Why do I say that? Because the national jurisdictions, with the different characteristics, which are relatively minor when you compare Serbia, Croatia, Montenegro, or Bosnia, my colleagues still face the same or similar problems. And there is a pressing need to do away with those issues. The Hague Tribunal required 8 years, being in a position to change its own rules. I'm afraid that the changes necessary here will be much longer, because there are only two ways. One would be to change the penal code wherever necessary. The other way being through jurisprudence, which should result in a more precise interpretation of certain legal norms and standards and corrections thereof through the exercise of appellate courts. Of course, this is linked to several other questions. The first question would be how to channel these omissions pointed out by defense. In national systems, of course, these should be tackled by bar associations, which can use their own channels, their own system, in cooperation with the Ministry of Justice and so on and so forth, so as to exert influence over the changes of laws. Although such associations deal with the whole range of issues of advocacy. In that sense, the role of ADC should expand to include cooperation with national bar associations to provide professional expertise and assistance in the changes required when the application of penal codes is concerned. Of course, the accusatory system was, in a way, enforced upon us, although I personally prefer it because it offered more excitement during a trial. But in terms of the right to a fair trial and the position defense, as things stand now, we are still very far from the standards set up by the tribunal. Unfortunately, similar bodies do not exist in other countries of the region. In Serbia, the role of the National Council for the cooperation with the Hague Tribunal was quite significant for a while, and perhaps they should continue operating in some shape as the organization which is at least familiar with the techniques of collecting evidence required by defense and the general public, of course. If I were to define the problems which crop up during the proceedings themselves, I would say as follows. The first problem is the right of defense to collect evidence during the investigation phase to its own benefit. According to the legislation of certain countries, this right is limited to the right of defense to prepare evidence alone. On the other hand, such evidence can be found across the territory of several states. many war crimes, many people who are accused for war crimes are indigent, and the system of financing does not constitute models in how defense can play a role in that. That system also does not recognize what activities need to be undertaken by defense during the investigation phase. Here, I primarily have in mind this way defense teams would be financed for their own activities during investigation. As we all know, in war crimes cases, this stage is crucial, bearing in mind the temporal and spatial distance of crime locations, and bearing in mind the body of evidence, which is quite voluminous oftentimes and can be found in different locations and at a different time. The second important circumstance is that there is no obligation of a public prosecutor to disclose all evidence collected during investigation, i.e., they can disclose only such evidence as would be used in a trial. And in combination with that, they see no obligation to disclose material under Rule 68, which would be exculpatory. They carry out that assessment themselves, and there is basically no control, judicial control exercised over that exercise, let alone any defense possibility to try and find out whether the prosecution had any such evidence and how they assessed them. We see, on the basis of their work, as was referred to by Ms. Vidovic, there is much space for them to manipulate or simply remove such evidence. There is also no access to the database, and given the fact that a tribunal will stop its work soon, this access is even further limited. Until now, our colleagues working at the tribunal had access to the open database, and now their number is being reduced. The open database now seems far removed from one of its core functions, which is to be used in proceedings before local courts, not only by the prosecution, but by defense as well. In this system, to cut things short, the import of defense has been marginalized, boiling down to their sheer participation during trial, without any possibility to significantly contribute to the functioning of the proceedings before the trial itself, on either side of the scale. That brings us to a situation where trials themselves have a bitter taste, where there is a need to conduct proceedings and finish them quickly and charge many without due regard for their right to a fair trial. For as long as the existing jurisprudence and legislation is not changed in that regard, creating firmer rules, including prosecutorial obligations to cooperate with defense in a plethora of different ways, we will not have proper justice. It may be efficient or speedy, but not just. Thank you.
Thank you, Mr. Snitch. I think it was good to sort of round out then and hear more from how some of these things are being implemented, or how some similar themes are coming out in the domestic war crimes chambers, creating systems that work, as it were. And in this case, what you're talking about, you raised a couple of issues. There's always indigence financing issues, but there's also, of course, then back to disclosure issues, the size of cases, vis-a-vis the speed that they need to run at to maintain fair trials are all there. But also you raised the issue about at what point the defense have the ability to investigate, which I think is an interesting topic that goes to sort of the rules and systems that we put into place. should the defense be investigating at the initial stages, even before there are actually even accused? Should you have it at a situation level? These are all discussions that come up as far as when people have access to evidence, how much should they have? Should it be a dossier? And should the judges also have it as well? These are discussions and recommendations that you can all make, as we've said. We probably then, I want to thank everyone on the panel again, actually, but I want to see, we have 3 minutes for questions, actually, but we'll probably take 3 to 5. So I have 1, 2, lots of questions, at least 3 over here I saw. Okay, we'll start back here, actually, was the first hand, so.
Thank you for having the opportunity to address this meeting. I'm Branko Lukic, leading counsel presently in Mladic case. And I'm actually a practitioner from Belgrade. And what my colleague Vishnich emphasized is the problem for the defense dealing with the documentation. I think that we should have as a conclusion for this conference to organize somehow the transfer of documents from the tribunal that would be reachable for the defense or to the defense. In the present legal system in Serbia, it was not possible for the defense almost at all to get access to the documentation. We heard this morning how the prosecutor from Sarajevo, Ms. Gordana Tadic, praised cooperation with the prosecution. And I know that the great effort was implemented into having efficient system here in Bosnia and Herzegovina, especially in the prosecution. And that's the case for the prosecution in Serbia as well. Defense from 0 to 10 in Serbia is at level of 0. We are not even at level of 1. So if we want to talk about any kind of fair trial, we have to think and organize, and I'm ready to participate in it, to organize feasible system that would get the defense access to those documents. If we do not have it, we will not have a single fair trial of war crimes in Serbia. And I'm happy that Jelena from the prosecution from Serbia is here. I think we have excellent cooperation. We had it, and I hope we will have it in the future. And I'm sad that Mr. Bramertz left just before Tomislav Višnjić started to talk, and I was eager in our effort to transfer the message to him, but I hope that his staff will tell him about the really serious problem. We have to know that even the defense lawyers who participated in the cases in front of the tribunal and have access to the documents lose that access after a certain amount of years. When we stopped to be lawyers for the defendants, and that happens after the verdict is final, when the second instance verdict is in force, we do not have the access to those documents. For example, I had 8 clients in The Hague. I have the access only to Mladic documents now. All other documents from all other databases, I'm cut off, and we have to return the documents in our possession, either in paper or in electronic version. So we are not allowed to have those documents, let alone the access of the lawyers from Serbia who never represented clients in The Hague. So I hope that this problem would be recognized and dealt with in a proper manner. And I'm sorry for taking this much time. I know we are all hungry on Thursday. Thank you for your attention. And I'm happy to transfer this message to the prosecution in The Hague, Serbia, and the rest of you. Thanks a lot.
Thank you very much. We had one down here and then one back there.
Hvala. Obratit ću se na materinjem bosanskom jeziku.
Thank you. I will speak to you in Bosnian. I'd like to greet all of you, the panelists and those in the audience. I would especially like to thank Mr. Schoenberg for his presentation about the omissions and errors made by the international community, which should have reacted as early as 1990. I asked myself, what happens after the ICTY closes its door, which to a great extent has corrected the positions of different peoples in the Balkans. And once war crimes and the perpetrators were sentenced, at least the intelligent part of the population tried hard not to identify with them. After the ICTY closes its door, there should be an institution that will serve to prevent any further conflict in the Balkans to take over, which will monitor any kind of new trends which may lead to a new conflict. I say this because the ideology of conflict in the Balkans will not be resolved until there are still those who seek to promote those very intentions time and again. Thank you.
I see in the back there's one and then two. So we'll take those last two right over here.
Ja sam Senka Nožica I još uvijek sam...
Senka Nožica, still a practicing attorney, defense counsel before the ICTY. A few of my own observations. I have to express my pleasure with being able to represent in Bosnia-Herzegovina as well. As opposed to the problems faced by defense counsel in Serbia, we are in a much better position. First of all, because we have the OCO, and we can turn to them for any documents we require. Secondly, we are in a position, and that needs to be stated publicly, for having the BIH state court, which mainly tries war crimes. And professionally speaking, it is at a level similar to that of the Hague Tribunal. There are still problems, but we have quality trials and good cooperation with the court. What is a problem, though, for me, is this. I was a prosecutor for 17 years before the war, and as the war started, I became a defense lawyer. I see the discrepancy, the gap between the Hague Tribunal and domestic jurisdiction in the way prosecution officers approach war crimes cases. In The Hague, we had perfect cooperation with our colleagues from the prosecution. They would forward all documentation and enable us to get in touch with every witness. They hid nothing because they stood by the principle that should be honored by any prosecution's office, which is to prove the truth rather than hide and win in court because you represent a certain side. Unfortunately, in BIH, at all levels, wherever there are war crimes cases and trials, the principle in place is still, let us fool defense counsel. Let us prevent him from accessing all documents, which may result in the biggest problem of all, the problem being an innocent person being accused for something. There are documents in existence proving its innocence. I may be drastic in saying this, that it may result in such circumstances, but those of us who worked before the Hague Tribunal, directly cooperating with the prosecution, cannot go silent when we see this happening, I presume, in all of the countries of the former Yugoslavia.
We're going to take one final question, and then we'll do them all together.
Ako pozdravljam sve prisutne, ja sam Mirca Duratović iz Prijedora.
Mirsa Duratovic from Prijedor, former inmate in Omarska, Manjača, and Trnopolja, was a minor then and used as human shield. I saw my 15-year-old brother killed, and 47 members of my expanded family were killed. I will touch upon this issue of from the point of view of a survivor. In terms of the financial assistance offered by the Hague Tribunal to the accused, we believe that too much money was simply made available to the accused, and as registered by the ICTY register, in the Žigić case, he received millions of euros for his defense, which he divided or split up with his own attorneys. Maybe some defense lawyers will be angry with me after saying this, but this was a finding of the ICTY registry. Žigić split up these funds with his attorneys. First of all, these people robbed us of our property. They became rich during the war. After the war, they were important figures. They bought and sold state-owned companies, and then they ended up before the Hague tribunals, and the Hague tribunal gave them €1 million. They returned to Prijedor, and they are nowadays the eminent citizens of Prijedor, the heroes of that town. Their families enjoy privileges, their children receive scholarships. Their wives have precedence in attaining a job. And what about the victims? We have been forgotten by the local community, by the Hague Tribunal, and it's a great minus for the Hague Tribunal for the enormous assistance they provided to the accused. As for the witnesses, and we heard some of them yesterday, some prosecution witnesses, they did not enjoy nearly such a good treatment by the registry or the OTP there. Let us be brief, so that we do not leave with a statement like this. Yes, there were such scenarios where funds were abused. However, I can tell you that the tribunal did its utmost to have appropriate disbursement of funds. Every document was checked, double-checked, and there was a financial department which checked the indigency of the accused. Ultimately, the tribunal is the one who uncovered the situation you referred to. I can tell you that these cases were truly exceptional and very rare. The tribunal, of course, needs to make funds for defense available.
To answer, thank you for all the contributions. Judge Schoenberg is going to address the question that was asked in the front, and then Mr. Snitch is going to make a comment on the first comment.
If I understood you correctly, because I had no translation in the very beginning, it was about prevention and that these things never happen again. What can be the contribution of our tribunals? Yeah, of course, I think the presentation of facts, they can't be really denied by serious people, but unfortunately, there seems to be kind of red line that, for example, denial of genocide must be criminalized. It has been criminalized in Germany, the denial of Holocaust. It has been criminalized in Rwanda, the denial of genocide there. And of course, some people tend to argue this is a denial of the freedom of speech. But on balance, I am in favor of, as a preventive measure, to take the opportunity to have this crime. And going even one step further, I think for the future, it would be recommendable to have a set of really specialized counsel, both for the prosecution and for the defense, and also for judges, all of them being kind of standby organs of a tribunal to be established immediately when there is or should be, unfortunately, wherever in the world the imminent threat that a genocide starts. Had we had this, for example, in Rwanda in place, then and intervened immediately, because according to the findings of the trial chamber, of the appeals chamber, the genocide was already foreseeable and could have been in particular the people from the media and state organs could have been convicted on the basis of incitement to genocide. And I reject these claims that incitement to genocide is superseded by the freedom of speech. This is not the case. It's a crime under international law, and we all know that our action is limited, but I hope that the work of the ICTY has contributed both to prevention and also to kind of attempt at least of reconciliation in the area. But as ultima ratio, we need this additional protection by criminal law.
Ja ću samo kratko da se nadovežem.
Let me just add to what Senka has just said, or to remind her, this love between us and the prosecutor that you just mentioned only started when they were forced by the rules to actually disclose the evidence, disclose the documents. So it's when the rules made them do it. Why am I saying that? Because if the accusatory system is such that every side wants to win, of course, I would take it myself if they wouldn't give me the documents. I don't hold it against them. I don't call it against Ibro Bulic or my colleague from Belgrade. But fair proceedings must force them to do it as part of their job. In addition to being prosecutors, there have to be officers of justice, or however they're called in any other system. But in some current systems, in this case I'm in Serbia, this obligation of the prosecutor is not articulated clearly, nor do I think that it actually exists as it should in the law. I do apologize, and I think I understood exactly what you meant. Thank you.
And there's loads of lunch discussion. So I just want to take 1 minute, and I actually timed this meticulously. We did take 1 minute more than the prosecution panel, and I will admit that, 1 minute. And so in this next 30 seconds then as well, I just want to thank the organizers, in particular the ICTY offices, the presidency, who really facilitated and invited us here, and I think this is on behalf of the whole panel. I want to thank the ADC, I want to thank Dom Kennedy for helping us organize all of this. And if you have those suggestions, those ideas that came out, the whiteboards are out there. The address is ictyconference2017@gmail.com. And other than that, hvala, prijatno.
Many thanks to everyone. May I just remind you that we'll still start at 14:30 as planned, even though we'll have half an hour less for lunch break. Thank you.
Ja kad sam počeo radim u tribunalu i sad treba da se daju izjave, znaš, ono prve javne.